Well, good morning, everyone, and welcome to this first of a short series of webinars that Seashell Trust have put on. I'm very pleased to be here. Thank you very much for having me and to have this opportunity to speak for a couple of hours about some of the key legal issues affecting disabled children, young people and their families. I'm Steve Broach. I'm a barrister at 39 Essex Chambers, and I specialise in cases involving disabled children and young people. I'm one of the authors of Disabled Children, a legal handbook available in all good bookshops and published by the Legal Action Group, and also available to download free of charge on the Council for Disabled Children website. And I'll put in the chat the title of the book in case anyone wants to Google it. It's Disabled Children, a legal handbook. And that really is, I hope, a useful resource for anyone who's interested in the law in this area. So it's a very interesting time, of course, to be a practitioner in the law in relation to disabled children and young people, because we're expecting a green paper coming out very shortly, which may propose some very significant reforms to the law. But we, of course, did have a very significant set of reforms as recently as 2014 in the Children and Families Act. And there's there is a school of thought that actually the key issue isn't that there's anything wrong with the law as such. It's really an issue of implementation and compliance with what is actually already quite an effective set of legal entitlements for children and young people. The focus of today's talk is going to be on support at school. One of the very important things to note about the scheme, the legal scheme for disabled children and young people, is that the vast majority of children and young people with additional needs won't have an education, health and care plan, which is the key statutory document that was created by the Children and Families Act, replacing the old statements of special educational needs. So those children don't have a statutory entitlement, which we'll be talking about in another session, to the kind of specialist individualized support that children with more significant levels of need will have as a result of their EHC plan, when it becomes the local authority's job to ensure that their needs are met and to secure the provision that that plan specifies. So we have to look elsewhere for the duties that are particularly important for children in school, particularly those without an EHC plan. And there are two key sources of law that we'll look at today. One is the Children and Families Act itself, which does have some important things to say about what schools have to do. And we'll focus on that first and spend the first hour perhaps looking mainly at that. And then after the break, we'll be looking at the Equality Act and the duties that are imposed in relation to disabled children and young people by that act, which require, for example, reasonable adjustments to be made. So that's the general scheme of the talk. And I will be sharing my screen at various points to show you different resources. If I could also please encourage people to use the Q&A function. So it's set up as a webinar today. So obviously feel free to use the chat for general points or issues like, for example, the link to the handbook, which I'm sure can be provided. But if you've got any specific questions for me, it's really helpful if you could put those, please, in the Q&A function, and then I can see them as we go through and answer them at the right point, possibly answer those in writing that don't need to be answered generally. However, please do ensure that the questions you're asking are general. So that means that you ask something that's got a question mark at the end, and that it's a short point that might be of interest and relevance to other people. What I can't do today, people will understand, I'm sure, is give legal advice. So, of course, I do give legal advice all the time when I'm instructed to do so, directly or through solicitors, but I can't do that in a general discussion, as people will understand. So with that caveat, please do use the Q&A function to ask any questions that you'd like to as you go along. I definitely find these discussions are more important, more useful, more helpful for people when there are lots of questions flying in, and I'll do my best to answer as many of them as I can. Okay, good. So let's start then. I'm just going to bring up my screen, close down a few things that shouldn't be letting people see. And what I'll do is show you how easy it is to find the legislation itself. So hopefully you can now all see my internet browser. And I'm going to just search Children and Families Act. There it is. And what you're looking for when you're looking up the law is you're looking for the legislation.gov.uk website, because that's the official source. And hopefully it will be up to date. And the Children and Families Act is I think, up to date, because I don't think it's been amended since it was originally enacted, as it says here. Now, the Children and Families Act did a few things that were of great importance, including reform the law in relation to adoption and family justice. But what we're concerned about is part 3, children and young people in England with special educational needs or disabilities. So you might think that this will have all the law that you need if you've got a disabled child or young person. And you'd be reasonably entitled to think that, and unfortunately you'd be wrong, because what is essentially the case is that the Children and Families Act is an Education Act with some health and social care provisions bolted on to them. It's not, for example, where you would find the key duties in relation to social care for disabled children and young people. Those are found in the Children Act, bolstered by the Chronically Sick and Disabled Persons Act 1970. So in later episodes of this series, we'll be looking at those duties. But what this scheme does do is establish, first of all, what is a special educational need? And secondly, what does the state have to do in relation to children with special educational needs? So I'll just take you to some of the key provisions in the Children and Families Act. First of all, section 19, which is the first section in part 3. What section 19 says is that in exercising functions under this part, in the case of children and young people, local authorities, so this isn't about schools, it's about local authorities, must have regard to some key points, the following matters. Now, the first 3 concern views, wishes and feelings of the child, importance of their participation, and importance of information to support participation, all good stuff. The fourth one is the one that's particularly attracted interest, the need to support the child, young person, in order to facilitate the development and to help him or her achieve the best possible educational and other outcomes. So that's the aspiration, that's the goal for the Children and Families Act. And you see right at the beginning, this idea of education being the priority, because it's educational and other outcomes that we're talking about. The next provision in the Act that we need to look at is section 20, which is our definition of special educational needs. So we see that a child or young person, and in broad terms, a young person is someone aged 16 to 25 in this scheme. They're still children, 16 and 17-year-olds for many other purposes, but for the Children and Families Act, a 16 or 17-year-old is a young person. So a child or young person has special education needs if he or she has a learning difficulty or disability. And that's quite important. So there's 2 possible routes in. Either you've got a learning difficulty or you've got a disability which calls for special educational provision to be made for him or her. And then we have a definition of those 2 things. So a child of compulsory school age or a young person has a learning difficulty or disability if he or she, A, has a significantly greater difficulty in learning than the majority of others at the same age. So that's going to be generally the routine. Does the child or young person have a significantly greater difficulty in learning than the majority of others at the same age? And significant in law usually means more than minor or trivial, i.e. something noticeable. And then the second way in is, and we see you can be either, because it's or, has a disability which prevents or hinders him or her from making use of facilities of a kind generally provided for others at the same age in mainstream schools or colleges. So your disability, if you don't have a significantly greater difficulty in learning, you then have to meet this test, a disability that prevents or hinders you, makes it harder for you to access mainstream facilities. And there's immediately there a connection, of course, between the kinds of language that the Equality Act uses as well. So the short point here is that the definition is the test is not set too high. And very many children and young people, as we know, will have special educational needs. I think it's roughly 1 in 5 of the population. Just to note that for young children, those under essentially 5, you meet this test if it's likely that you will fall within these categories when you reach compulsory school age. And note that having English as a second language doesn't qualify you as having special educational needs. So that's the gateway test. And then we also need to understand, well, what is special educational provision? And also, while we're at it, let's think briefly about what healthcare provision of social care provision. So special educational provision for children over 2 is educational training provision that is additional to or different from, so a well-known phrase, that may generally, for others of the same age, in. This is quite important. Mainstream schools in England. So the comparator now, in order for you to qualify for SEP, is that you need something that is additional to or different from what schools do generally across the country, not what your own local authority schools do. There's a much more general comparison. And then if you're under 2, it's educational provision of any kind. Now, just while we're here, healthcare provision means anything the NHS provides, sorely. Social care provision means anything that local authorities provide under their social services functions, so under the Children Act or the CSDPA. But importantly, healthcare provision or social care provision, which educates or trains a child or young person, is deemed to be special educational provision. So that's why, for example, speech and language therapy is almost always special educational provision, because the effect of it is to educate or train the child or young person. It doesn't matter who's providing it or who's funding it. It is, in law, special educational provision, as will many other kinds of therapeutic provision be. So those are the gateway sections, the kind of definitions sections. Let's see, where do we need to go next? So we'll skip over the local authority duties because we're focusing at the moment on schools. We see that there are duties to promote integration, as you'd expect, to have joint commissioning arrangements. Those are all on the local authority. School governing bodies, interestingly, at section 29, have duties to cooperate. So in relation to all of these functions, they have to cooperate with local authorities and yes, there we go. So the appropriate authority must cooperate with each responsible local authority in the exercise of these functions. So schools and local authorities are supposed to work together under section 29. The local offer, which people will be aware of, is again another local authority duty to publish information, which we'll come back to in another session. And then we have duties in relation to EHC plans start to come in here in section 33. But importantly, for the purposes of today's talk, children and young people with SEN but no EHC plan. So what we see is the child or young person in that scenario must be educated in a maintained nursery school, a mainstream school, or mainstream post-16. Subject to these 2 very limited exceptions, they can go to an independent school, a non-maintained special school, or a special post-16 institution if the family okay, essentially. And then there can be a limited admission for assessment, essentially, for other children and young people on the way to them getting an EHC plan. Otherwise, all children and young people with special educational needs who don't have an EHC plan must be in mainstream schools. So that's section 34. And then section 35, very importantly, heads towards inclusion, what meaningful inclusion means. So where a child with SEN is being educated in a nursery or mainstream school, those concerned with making special educational provision for the child must secure that the child engages in the activities of the school together with children who do not have special educational needs, subject to subsection 3. And so that they have to do that as far as reasonably practicable and so far as is compatible with them getting the SEP they need, provision of efficient education for the other children, and the efficient use of resources, which we're going to see are broadly speaking the exceptions that apply for EHC plans as well. But what we see again in section 35 is a very strong steer towards inclusion, and not just presence in a mainstream school, but actually engaging in the activities of the school together with other children. So I think section 35 is quite important and can be overlooked. I'll just pause there to see if we've got any questions. Okay, so there's a couple of points that I'll try and pick up later on, one of which involves reasonable adjustments duty. I'm afraid the first 2 questions are, frankly, case specific, which is going to make it difficult for me to answer them today, but I'll do my best. The third question is more general, and I can answer that. The suggestion is that a child has an EHCP they should go to a specialist school, they can't be forced into mainstream. No, that's not right. As we'll see when we get to the HCP section, there's still a presumption in favour of mainstream education for children with EHC plans. If parents want a special school, then the question will become, are any of the exceptions to the right to parental preference applicable, in particular cost or the efficient education of other children, or potentially unsuitability for the child themselves. But we'll come back to that when we get to the EHCP talk on another day. So section 35, as I say, very important in terms of meaningful inclusion. Section 36 then is the gateway provision for EHC plans, because it tells us about EHC needs assessments. So again, we'll be coming back to that on the EHC plan talk. But for present purposes, it's very important to note that if your child is at school and is struggling, and you are concerned that they need additional support, additional resources, or maybe they need to go to a different school, for example, a special school, then the way through that is to request an EHC needs assessment. And importantly, and this is sometimes misunderstood, the child's parent or the young person can just request the assessment themselves, as one of my clients is about to do. You don't have to wait for the school to do it. So you can just go for it yourself, and every local authority should have a mechanism, a pathway for parents to make that request. And then sections, as we see, 37 to 50 are all about EHC plans. So we're going to skip over all of that for present purposes. Appeals, mediation, and dispute resolution, again, is pretty much generally about EHC plans as well. And then we have a series of duties on local authorities, again, not looking at that today. But then we have some important duties in relation to schools, because again, it can sometimes be overlooked that the Children and Families Act does impose duties directly on schools, as we've already seen. But perhaps my favourite of the schools duties, and the one that I tend to bang on about the most, is section 66. And as we see, this is a duty as it's headed for schools to use their best endeavours to secure special educational provision. And this section imposes duties on the appropriate authorities for the following schools. And there's a long list there, which includes mainstream schools, maintained schools, academies, nurseries, alternative provision settings, colleges, and so on. And the duty is here at 66 too. So if a pupil or student has special educational needs, the appropriate authority, so the governors or the academy proprietor, must, in exercising its functions, use its best endeavours, we'll come back to that, to secure that the special educational provision called for by their SCN is made. So that's a duty on the school, not on the local authority, to emphasise. And it's also a duty that is generally applicable in relation to all children and young people with SCN, not just those with the EHC plans. And in fact, those with the EHC plans, it will be said, the school doesn't need to use its best endeavours, because the local authority has a hard-edged duty, a must duty, to secure that provision. So really, section 66 is particularly important for the group of children and young people, the majority of children and young people with SCN who do not have any EHC plan. What does best endeavours mean? It's quite a high test. It's distinguished from reasonable endeavours. So best endeavours means you really do everything you possibly can to make this happen. So it acknowledges, instead of just saying shall secure, using your best endeavours to secure means that there may be situations where you can't do it. So it allows for the possibility that the school can't do it. But generally speaking, the school should be able to secure the provision that the child or young person needs. Or for example, if they can't, the very next thing they should be doing is working with the family to try and get the child or young person an EHC plan. So it absolutely isn't good enough for schools to say, oh, we can't do it, you'll have to go and talk to the local authority. They have to use their best endeavours to secure that SCN is met. So I would definitely bookmark section 66 if you are a child or young person or a parent who is concerned about the school's obligations to meet special educational needs. Also in this subpart, I've got duties in relation to SENCOs. There's a requirement for every school to have a SENCO, and there are some SENCO regulations that specify who that person must be and so on. That's in section 67. Section 68 is then an information provision duty. So if special educational provision is being made, then the parent or the young person must be told about that, as we would expect. And then section 69 is the requirement to publish an SEN information report. And we see what has to be covered in the SEN information report. So arrangements in terms of admission, ways in which disabled pupils are prevented from being treated less favourably, facilities to assist access, and then the accessibility plan, which we'll see the governors have to produce under the Equality Act. So that, I think, I'm just going to go back to the table of contents, is what I wanted to show you about the Act in terms of schools. The next thing we need to look at, I'll have a quick look at questions first, is the Code of Practice. And we see that the SEND Code of Practice, which people will probably be quite familiar with, is a statutory code issued under section 77 of the Act. The Secretary of State had to issue it, giving guidance about the exercise of their functions to, for example, governing bodies. And those persons listed in that subsection here, including governing bodies, must have regard to the code. It's very important to keep that in mind. The code is have regard guidance. There are different kinds of statutory guidance, and have regard guidance isn't the strongest kind. The strongest kind is what's described as act under guidance, which is guidance that must be followed in the absence of a considered decision that there's good reason not to do so, say the court. Have regard guidance is, as the name suggests, something that has to be considered. So a local authority or a school would act unlawfully if they just ignored the code, but they are entitled to consider what the code says, consider the guidance it gives, and then do something different. Why then is the code, as we'll see, full of the word must in bold letters? The reason for that is that those are the points where the code is telling people what the civil servants in the Department for Education think the law requires. And so it's guidance on the law, and that's why the word must is used, guidance on where there are legal duties. But it's worth bearing in mind that's the civil servants' interpretation, and they're not the people who get to decide what the law is. Those are the judges, and there are occasions, and there is one occasion I can think of immediately, where the upper tribunal held that the code was wrong in the way in which it described the relationship between the HC plans and school transport duties. So don't treat the code as gospel, but it's obviously a very useful starting point for any understanding of the law. But I would encourage people to look up the law itself if you are sufficiently interested in getting the exact wording and the exact obligations nailed on. Before we go off to the code, let me look at the Q&A and see if there's anything else that comes in. So there's a question about private school provision that's not deemed a special school. So no, we saw earlier reference to parents being able to educate children in an independent school, but these duties generally don't apply to them. However, independent schools do have the Equality Act duties. So that's why very often that will be the most important thing to be referring independent schools to. When we get to the HC plan section, another time, independent schools can be named in the HC plans, and that then creates a new set of obligations that we'll talk about then. A question about whether schools would need to provide appropriate qualifications such as functional skills instead of GCSE opportunities, or the other way around. Yes, absolutely. So additional kinds of access routes to qualifications would be precisely the kind of special educational provision that might need to be made by a school using section 66 best endeavours duty. So yeah, a request to explain the best endeavours duty and what it actually means in practical terms. Well, I hope I've done that, but I suppose to try and take an example, say you had a child who needed a relatively modest amount of one-to-one support. So they only needed one-to-one support in certain lessons. It might be said that that child doesn't need an EHC plan because, as we'll see later, the overall test isn't met. But what they do need is some special educational provision, which the school should provide from its own pool of TAs, if it has one. And again, the difference here would be between a small village nursery school and a large urban secondary school would, of course, have different resources. So in that situation, the school would have to use its best endeavours to provide the TA for example, the science lesson. And if they weren't going to do that, they would need to explain why it wasn't not just reasonably possible, but essentially possible for them to provide that additional support. So I hope that's helpful as a specific example. A question that's been rephrased, thank you. I won't name the question, it's just for privacy reasons. What's the point of EHC, please, if they always fail to, if it always falls to families to hold local authorities and schools to account when provision isn't made? I'm going to need to come back to that question when we get to the HCP session, because today isn't about EHCPs. Sorry about that, or we won't have time otherwise. Are childminders and private nurseries outside the scope of the best endeavours duty? That's a really good question. Let me just go back to the wording of section 66. So when we look here at who has the duties, you have to show, if you want to rely on section 66, that the institution, if we call it that, is within one of these 6 definitions. And so I think, yes, if it's not a maintained nursery school, private nurseries and childminders would not have this duty. But again, they will have the reasonable adjustments duty and other duties under the Equality Act. So those are going to be particularly important there. Does section 66 still apply even if your child has an EHC plan? Yes, it does. But as the second part of the question goes on to say, what's the hard duty for EHC plans? It's in section 42 of the Children and Families Act, which we'll be coming back to in that session. So in those scenarios, local authorities have to secure the provision in the EHC plan. And so the school would be entitled to say, well, we've used our best endeavours because we've supported the child to get an EHC plan, and now it's over to the local authority to provide the necessary resources. If a school has a 6th form, which only offers places for A-level students, should they provide courses for SEN appropriate? Should they provide SEN appropriate courses? That's a great question. It's difficult to answer that question definitively, but my gut instinct, and again, generally, rather than providing advice, is that they probably should. It's hard to see how you could justify as a school only offering A-levels, given the combined effect of the Children and Families Act obligations and what we're going to see in terms of the Equality Act. So that's definitely a conversation that would be well worth having, and you can seek advice if you're not happy with the answer. Now, I may as well take this point now. Where do we get advice from? First of all, your local SENDIAS service. Of course, every local authority has to have an SCN advice and information service. Secondly, local charities and organisations. Thirdly, lawyers. Now, in terms of accessing lawyers, there are, of course, fantastic NGOs like IPSI, SOS, SCN, who work in this space. They're all massively oversubscribed. You may be able to get lucky and get support there, which should, I think, be free, or perhaps SOS, SCN may charge a very low sum for things like writing a pre-action letter. If you need to instruct a lawyer privately, then there are 2 options for that. One is you can pay privately, and some families can and do that. And the other is legal aid. Now, the problem with legal aid is that it is only available where families have extremely limited means. It can be available in the name of the child and should be available for young people themselves, certainly those over 18. But for children, there's often a stage where the parental means would be taken into account, and that means there's at least a sum of money that needs to be paid. And there's a list of lawyers who do work in our area on my blog, which I will now hopefully bring up on the screen share. There it should be there. Is that the right one? Yeah, there we go. So I'll pop that link in the chat. I see there's some contributions in the chat as well. I'll double check those in a second. And so there's a number of firms and organisations that are listed on the blog who may be able to provide advice. So I hope if I'm not able to satisfy your needs today in terms of general responses, you'll be able to access the specific advice that you need. After that, after the talk through one of those organisations. If a school's not ensuring best endeavours are used, not doing its section 66 duty, how do we hold them to account? Great question. Okay, so the first thing obviously would be to raise the point. And who do you raise that with? Well, whoever you think in the school is likely to be most sympathetic. That could be the SENCO, it could be the head, it could be the chair of governors, it could be the SEN lead governor. Formally, of course, it's the governing body or the academy proprietor who has the duty, so that's where the formal request would go to. But people will know how best to communicate with the school and where they're most likely to get a sensible response. if you don't know, then just write to the chair of governors and copy in the head of the SENCO, and they can work it out amongst themselves. And what you would do, I'd suggest, is say, dear school, I'm sure you're aware that under Section 66 of the Children and Families Act, you've got a duty to use your best endeavours to secure the special educational provision that my Johnny needs. He needs X, he's not getting it. What are you going to do about it? That might be quite a sensible starting point. Now, if that doesn't work, then you need to escalate it. And of course, there are several routes to do that. One will be through the complaints process. And I would suggest that for relatively low-level disputes, where the provision isn't critical, perhaps, that would be the appropriate way to go. The more formal routes would be either a judicial review against the school, which is upping the ante really quite considerably, but I'm regularly instructed on judicial reviews against schools. It's certainly something that can be done. Or when we get to it, a disability discrimination claim under the Equality Act, which goes to the tribunal instead. Of course, the third thing you might want to do, and may well want to do in parallel with any of those things, is request the HC needs assessment. Because if your child's got needs that aren't being met by the school, that's a big red flag for the possibility that they need in the HC plan. And there's no reason why you couldn't do that at the same time. But as always, I would say, for anything significant, the real thing to do is to make sure you get specialist advice as quickly as possible. And that could be, as I say, from a whole range of different sources of potential advice and support that those I've just mentioned and appear on my blog. So I'm just scanning the chat. I don't think there's anything here that is urgent for me to deal with. Oh, there's an interesting question about how far do you have to push? Local authorities are notorious for pushing back until they're taken to the tribunal. Well, frankly, perhaps sometimes until the day of the tribunal in some cases. Is it worth going in guns blazing with a cover letter from a lawyer to indicate you're not messing around? Well, of course, as a lawyer, I think that was an excellent idea. No, I definitely don't think that's how people should start any dispute, whether it's with a school or a local authority. But I do think that families, and very much contrary to the view that's expressed in the Local Government Association report this week that's come out, my experience is that families often wait too long to take legal advice and hope that the right thing is going to be done and hope that they can sort things out, and only come to lawyers when basically it's reached crisis point. So I would definitely suggest that getting legal advice earlier rather than later is a good idea. And of course, good quality legal advice might well be, perhaps you can go away and sort it out yourself. You don't need lawyers yet, but you won't know that until you've taken the advice. So to the extent you're able to, accessing legal advice early is, I would suggest, always a good thing. So I hope I've now dealt with anything else that was in the chat that was specific for me. Yeah, so a question about when there's continual failings, do you just continue to raise more and more complaints? No, I would say absolutely not. What's the point? That's exactly the kind of situation where you need to speak to a specialist education solicitor and consider whether, in fact, the remedy here needs to be judicial review. So judicial review is the remedy of last resort, as it's always known, and you cannot just go straight to judicial review unless there is no other convenient or effective alternative remedy. So, for example, in cases where you have a child or young person out of school, and we'll look at those duties perhaps very shortly, actually, you might well want to say that you're not going to go through the complaints process because it's so urgent, they have to be brought back to school. And you are therefore going to go straight for judicial review, because judicial review requires you to use the pre-action protocol, where you send a letter to the other side and give them an appropriate amount of time to respond, which is generally 14 days. It can be less, including a lot less, a day in really urgent cases. But you don't go straight to court. There's always the opportunity for them to do the right thing. But they then have a very fixed timescale and they must respond, or else you are entitled to go to judicial review. So I hope that both those who are interested in legal remedies will see that the blog I've just shared in the chat is useful there. So I was going to go next to the SEN Code of Practice. do that. Because I'm going to go through the code in any detail, because frankly, that's not going to be very interesting for anyone. You can read it yourselves. Just to show you where you need to look. So now, a couple of things. First of all, of course, it's now quite old. So January 2015, I would very much expect that one of the things that will come out of the new green paper, if it is imminent, is a commitment to update the code. But until it's updated, it remains in force. And as we see, it's statutory guidance to everyone relevant, all relevant people have to have regard to. So how's it structured? First of all, you've got the principles and what they describe. This is the section 19 duties, essentially, as being the key principles that the government expects everyone to follow. So that's always worth looking at and potentially quoting in any letters you're writing. Chapter 2 then deals with the information, advice and support services. And chapter 3 deals with joint working. Again, all of this may be of some relevance for you. Chapter 4 deals with the local offer. And then how the code is structured is by age range, interestingly. So we start with early years provision. And what I was going to flag that's of significant importance is this concept of SEN support. Now, this is essentially a concept that's in the code, so it's guidance, but it's a 4-part cycle. We see it set out straight away here of assessment, planning, delivery, and review, which is then repeated for each of the age ranges. So we see that first of all for early years, and then we see it for schools. So SEN support for schools, where's that? SEN support in schools, here we go. So we see that where a pupil is identified as having SEN, schools should take action to remove barriers to learning and puts effective special educational provision in place. Paragraph 6.44 of the code there is your friend, and you may well want to be quoting that in your letters and emails as well. This SEN support should take the form of a 4-part cycle through which earlier decisions and actions are revisited, refined, and revised. The growing understanding of needs, etc., the graduated approach. And so then we see more guidance on assessment, planning, delivery, do, and review. And so where that's not happening, again, point to the code of practice and say, this isn't happening, this isn't good enough. You've got to explain, you've got to show that you had regard to this, at least, frankly, you've got to do it. But the way out, of course, you probably wouldn't ever judicially review a school for failing to comply with any of these guidance principles, if you call them that, rather than obligations. You just apply for an EHC needs assessment. Because where this isn't working, where schools aren't delivering SEN support effectively, the quickest and most effective way out of that for families, I would suggest, is going to be through into the EHCP process. And we see that the code deals with schools, further education, preparing for adulthood, and then it has a section on EHC assessments and plans. So that really does show, I think, that we're not supposed to jump straight to EHC needs assessment plans. They are essentially at the end of this rather lengthy process, can be rather lengthy process of SEN support. But the other thing to flag is that children and young people are not expected to have to fail first before they can get an EHC plan. And there's no legal requirement for 2 cycles of SEN support to not have worked, or there to be any particular level of gap between that child or young person and their mainstream peers. We'll see when we get to the EHC plan talk. But essentially the question is, are the special educational needs significant enough to require the level of special educational provision that ought to be provided under an EHC plan? So the vast majority of appeals to the tribunal in relation to refusals to assess or refusals to issue a plan are successful. And that means local authorities shouldn't be gatekeeping the EHC process. And they should be responding rather more quickly, one might suggest, more positively, to requests for EHC plans where this school-based support isn't working. Okay, I'll go back to the questions for a moment. How common are JRs about the best endeavours duty? None, as far as I know, that have been decided. I've certainly run one or 2, but the vast majority of cases like that will be resolved. So one of the things to keep in mind is that the judicial review process encourages resolution by agreement at various points. For example, when you send a letter before action, the recipient of that letter will know that if they don't respond and don't respond positively, you will issue the claim. And at that point, they'll be exposed to having to pay your costs if they then concede it. So there's a big incentive for schools and local authorities to deal with the point at the pre-action stage. If that doesn't work and you issue the claim, there's another moment where the local authority and the school will have to, or the school will have to file an acknowledgement of service and their summary grounds of resistance, where they'll again have the opportunity to think, do we really want to fight this? And then if permission to apply for judicial review is granted, which is the first formal stage, that again sends a message to the school or local authority that the claim is at least arguable and they really might want to have another think about it. And so actually, when you look at the stats, very, very few judicial reviews go to a full hearing. A large majority of them settle, most of them with some benefit for the claimant, if not the full benefit. And that's particularly the case in disputes like this, because often the costs of the judicial review would significantly outweigh the cost of the provision that we're all arguing about. So it's unlikely and unusual that you would see a judgment in a case against a school, I would suggest, for failing to use its best endeavours duties. Doesn't mean, though, there wouldn't have perhaps been dozens of pre-action letters sent and even perhaps a few judicial reviews issued. But we won't know about that because those statistics aren't published and those letters never become public. Can the local authority refuse an EHC needs assessment? I'll answer that quickly because, of course, it's the link between the two parts of this training. Yes, they can, but the gateway is very low. The bar is set very low at this stage. So the test for an EHC needs assessment is essentially, firstly, that the child or young person has or may have special educational needs. And frankly, if you haven't met that test, then you're very unlikely to even be asking the question. So we can almost forget about that. And then the real question is that they may require an EHC plan in order to deliver the special educational provision. So it's just a may, a realistic possibility threshold at that stage. And the stats in terms of appeals in relation to refusals to assess are incredibly strongly in parents' favour. I can't remember the latest figure, but it's well over 90%. So I think local authorities that do refuse lots of EHC needs assessments would need to be able to justify that, given how low the legal test is. Trying to keep my questions in order, sorry. Why would a school not want there to be an EHC needs assessment? That's a great question. I've often wondered that myself, because legally, in law, the effect of there being an EHC assessment that leads to a plan is the school should be getting additional resources. I have my suspicion that the reason for that is that in some areas, local authorities don't comply with their Section 42 duty, and schools are left and somehow expect or consider that it's their job to then secure the provision themselves. And so they don't want to have what they see as a burden. But legally, that's completely wrong, because the burden is all on the local authority. So the answer to that might be that schools need some better legal training. Yeah, it's an interesting question about the problem not being the legislation, but the implementation. Will the review of the Children and Families Act in the House of Lords involve making adjustments to the law to reduce requirements on local authority? No, I don't think so. I don't think that Lord's post-legislative scrutiny is going to be the problem. The concern people have is, what's the Green Paper going to say? Because there's been some, I have no idea what it's going to say, by the way, but there's certainly been some discussion on the airwaves that there may be a proposal to reduce entitlements in some way. Now, it's important to bear in mind, a Green Paper is merely a set of proposals for consultation. They're usually followed by a white paper, and then by a draft bill, and then by formal legislation. So it's really still a very early stage in the process. You would expect it to take many years for the law to be changed from a Green Paper. So, obvious point, don't panic. We're not about to lose significant entitlements overnight. But if the government does propose to reduce and water down the entitlements, it will be very important that parents and young people's voices are heard in relation to that. And it would be very concerning, I think, because my view is very much that it's not, again, that there's anything wrong with the law. I take diametrically the opposed view to the Local Government Association, which seems to think that the problem is essentially pushy parents and aggressive lawyers. I think the problem is that there's large parts of the country where local authorities particularly are not complying with the duties effectively. And I wait to see what the Green Paper says about that, and whether that analysis is accepted, or if the case that it seems the local government association is putting forward is accepted instead. So yes, there should be opportunities to feed into the green paper. And importantly, it's a green paper, which means it's consultation rather than a white paper, which is decided proposals via a range of different groups, including, I'm sure, Seashore Trust, but also Contact as they're known, Special Educational Consortium at the Council for Disabled Children, no doubt will be doing a lot of work on it, and many others too, I am sure. And the reason I can say this is that I used to work in the voluntary sector. I should have said that at the beginning of the talk in terms of establishing my credentials. I used to work for the National Autistic Society, for Treehouse, ambitious about autism, as it is now. And then the last thing I did before I came to the bar was I set up and ran the Every Disabled Child Matters campaign at the Council for Disabled Children. So I'm still very close to a number of those organisations, and I have every confidence they will be working very, very hard once the green paper comes out. Now, lots of questions have been very interestingly, actually. I've got a whole raft of questions in the Q&A that are about reasonable adjustments. And all I'll say is I'll get there. We'll do the Equality Act bit after the break. But before we get to the break, I also want to show you another very important piece of guidance. Oh, in fact, I should probably show you the law first. That's a good idea. So let's start with the law. There's one other bit of the Children and Families Act that I was going to say people, but I better own it for myself. I sometimes forget to highlight, which is it's within this kind of miscellaneous bit at the end on the welfare of children. There's section 100, which is the duty to support pupils with medical conditions. So schools, again, the same kind of list we've seen before, must make arrangements for supporting pupils at the school with medical conditions, and they must, again, have regard to the guidance that's been issued by the Secretary of State. And so these are impairments, illnesses, which don't necessarily impact on the child's learning. So they don't result in special educational needs, and then therefore they're not also a disability that hinders access to facilities, but which mean that there are issues for the child being in school. Classic example might be epilepsy or diabetes. Let's briefly look at what that guidance is. So supporting school. Giving away the greatest secret, which is that lawyers basically spend most of their time Googling stuff like everybody else does. Here it is. So this guidance we see is statutory guidance issued in December 2015 for governing bodies and maintain schools and academy proprietors. And I won't go through the detail, but I will just show you the key points. So pupils at school with medical conditions should be properly supported so they have full access to education, including school trips and PE. So that's, again, a nice quote for any letters or correspondence. Governing bodies must ensure that arrangements are in place in schools to support pupils at school with medical conditions and ensure that school leaders consult health and social care professionals, pupils and parents to ensure the needs of those children are properly understood and effectively supported. So those are the three key points on pupils with medical conditions. There's also, if we scroll down, something that I've found quite useful before, which is a kind of table. Where has it gone? Here. So essentially, as we see, it's actually described as advice, but there's short, snappy boxes that provide advice as to who's supposed to be doing what in this quite complicated space. Governing bodies, head teachers, parents, pupils, school staff, school nurses, other healthcare professionals. Local authorities, importantly, are commissioners of school nurses for maintaining schools and academies and have joint commissioning duties. And then, in particular, CCGs. So CCGs commission other healthcare professionals and have to ensure that commissioning is responsive to children's needs. They should be responsive to local authorities and schools seeking to strengthen links between health services and schools. Since 2013, local authorities are responsible for commissioning public health services for school-aged children, but this is key. CCGs should be aware this does not include clinical support for children in schools who have long-term conditions and disabilities, which remains a CCG commissioning responsibility. That's the bit I was looking for. So if you've got a child with very complex medical needs, you start with the school, they are supposed to do what they can to support it. But if the health interventions that are required are beyond the resources of the school, it will be the CCG who then has to commission the relevant services, not the local authority. So it remains an NHS responsibility. You see the other bodies that are told the sort of broad things they need to do. So that's another important part of the jigsaw, and obviously links to the Equality Act duties that we're going to come back to after the break. Okay, a few more questions on the EHC plan. Sorry, on the not on the EHC plans, hopefully on the Q&A. Is the bottom line around finances? Our EdSite report states it recommends daughter needs an EHC plan, yet the provision is recommended under £6,000. Great question. Okay, so again, when we come on to the EHC plan talk, we will see that £6,000 is a relevant figure because that's the notional SEN budget that the school has. And if the child's needs can be met with provision that is less than £6,000 a year, then the question becomes, well, why else might they need an EHC plan? Why would the local authority need to maintain an EHC plan? And it might be something to do, for example, that the provision needs to be very carefully spelt out in a legally enforceable document because it's quite intricate or quite specialist. And the school couldn't reasonably be expected to know what to do without the guidance that an EHC plan could give. So £6,000 is certainly not a legal test, but it's a highly relevant factor to take into account. Would a severe nut allergy fall under medical needs? It certainly would. So if your child has a severe nut allergy, have a look at the guidance that's up on the screen now in terms of supporting pupils at school with medical needs. An excellent question. Are academies regarded as maintained schools, or do these duties not apply to them? The short answer to that is, broadly speaking, yes, they are. So one of the things the 2014 Act did was make academies be treated for the purposes of the SEN scheme in the same way as maintained schools, thankfully, because there are, of course, now so many academies, otherwise it would be completely ridiculous. So if a school is an academy, for present purposes, you can treat it in the same way as a maintained school. The key difference is that the legal entity with a responsibility will be the academy proprietor rather than the governing body. And you'll need to look at the academy's constitution to see how they've structured themselves in terms of who in practice is going to be dealing with complaints and dealing with challenges, because you don't have the traditional governing body structure. Okay, good. I think that all the rest are questions I want to come back to once we get to the section of the talk on the Equality Act. Now, one more important piece of the jigsaw before we get to the Equality Act. You can see I'm sort of clearing the decks here. Not only did the Children and Families Act not deal with all the issues in relation to health and social care that are important for our children and young people, it also didn't deal with all the issues that are important in relation to education. For example, the duty that is owed to children and young people who might be out of school. So this is the safety net duty. In the Education Act 1996, and the reason it's in the Education Act 1996 rather than the Children and Families Act is that it applies to all children, not just those with special educational needs. So it's highly relevant to, for example, to excluded children as well. And we see that it's headed exceptional provision of education in pupil referral units or elsewhere. Each local authority shall make arrangements for the provision of suitable education at school or otherwise than at school. So it's often referred to as education otherwise than at school, or EOTAS, for those children of compulsory school age. So we're looking at the 5 to 16-year-olds primarily, who by reason of illness, exclusion from school or otherwise, so there's our second otherwise. So there can be any factor here that means that you can't access school, may not for any period, again, importantly, receive suitable education unless such arrangements are made. So we can see why it's a safety net duty. It's to capture any child who, for any reason, may not be receiving suitable education in their school. Skip over 1A. We see the definition of a pupil referral unit. Any school established and maintained, specially organised, provide education for such children, is not a county school or a special school, is approved. And this is important. Under 3A, the education to be provided for a child in pursuance of arrangements made by a local authority under this section shall be full-time, or in the case of children with physical or mental health issues, such part-time education as is in the child's best interest. So the only way in which a local authority can get out of providing full-time education under the Section 19 duty is if they can properly say that it's in the child's best interest to receive less. They cannot rely on their own resources to limit the amount of provision that's made. And that was established in an old case called Ex parte Tandi, and is now expressly stated in the legislation. And we have a very important definition here of what suitable education means. So suitable education in relation to child or young person in England means efficient education, first of all, suitable to his age, ability, aptitude, and to any special educational needs he may have. So there has to be full-time provision, unless the child needs less, that is suitable for their age, ability, aptitude, and SEN in discharge of the Section 19 duty. And this is a duty that is quite routinely referred to in judicial review cases, because children who are out of school are often very vulnerable, and the High Court will be concerned to ensure that they are receiving some appropriate education. I've had quite a few Section 19 cases I've been involved in. A case that my client succeeded in, where a local authority was proposing that she went back to a school where she'd been sexually assaulted, sadly, her family had appealed to the tribunal, and the High Court held that that was such an unreasonable offer that the local authority hadn't discharged the Section 19 duty by relying on that school offer, even though ultimately the question was going to be decided by the tribunal. But in another case where the parents had what we thought were strong arguments that the school was unsuitable in the interim, the High Court said, no, that's a matter for the tribunal to decide. So again, the bar's set quite high here. If a local authority is offering anything that looks vaguely suitable, a judge is going to need to have it explained to them why it's unsuitable. But where local authorities fall down is that sometimes there's no offer at all, and that clearly breaches the Section 19 duty. Just while we've got the Education Act 1996, it's going to show you, it's got quite a lot of useful things in, like what a primary, secondary, further education, for example, what's a pupil, what's compulsory school age. But I was going to show you Section 9, because in some cases, Section 9 is still relevant in relation to children with SEN with EHC plans. It's the general duty, the general principle that pupils are to be educated in accordance with the wishes of their parents, so far as compatible with the provision of efficient instruction and training and the avoidance of unreasonable public expenditure. So again, you can point to that in any dispute or discussion to say, look, under Section 9, my wishes about how my child is to be educated are important, and you must have regard to that principle that my son or daughter is to be educated in accordance with my wishes, unless that's incompatible with others, the needs of others, and or would result in unreasonable public expenditure. But we'll see when we get to the EHC plan talk that the Children and Families Act deals with this more specifically in disputes about placements under EHC plans. Okay, so let me just quickly see if there's anything else I need to deal with now in the Q&A. You were told that full-time was only 8 hours. Well, that's obviously wrong, isn't it? Full-time is, what is it, 33 hours, however many hours a week a child goes to school. So that's concerning. Did I say it was reasonable not to expect schools to fully understand what a child's needs are without an EHC plan? No, I certainly did not. What I did say, though, was that there are some children who have needs, a very small minority, that are really complex, perhaps very unusual, and where the provision that's required to meet those needs isn't the kind of provision that's normally made by schools. And that might be a scenario where, even if it's not particularly expensive, it's still appropriate for the child to have an EHC plan. What obligations do local authorities and schools have to provide mental health support for a child who's struggling, or does that fall under CAMS? Well, again, look at the guidance on children with medical needs. But generally, yes. I mean, it would be unusual, I think, for a school to specifically commission a therapist, for example. What the school should be doing is supporting the family to ensure the child accesses that support through the child and adolescent mental health services as quickly as possible. We all know that waiting lists are a disaster in that area. So I think it's very difficult for schools, but I don't think the guidance will say that there's much the school should be doing itself in those kinds of cases. What's the age range covered by the Education Act 1996? Different bits cover different ages. As we've just seen, the Section 19 duty is applicable to those of compulsory school age, so that's roughly up to 16. Good. I think everything else in the Q&A is a reasonable adjustments question, which I will come back to. And on the chat, section 9, that's a big unless. Yes, it is a big unless. That's right. And that's why section 9 is not a particularly useful duty when it comes to EHC plans. But it is useful, I think, for those children, young people who don't have an EHC plan, just to be able to remind schools that there is a general legal principle that pupils are to be educated in accordance with the wishes of their parents. Anything else in the chat that I need to deal with? Is anxiety a mental illness? Yes, it certainly is. So anxiety and depression are in the diagnostic manuals. Of course, the question will be, does the child have a level of illness that meets that diagnostic threshold? And if they do, then it will certainly be treated as a mental illness and potentially, as we'll see, a disability. There's a few questions for links to documents. So that's probably to the medical needs guidance, isn't it? Let me just send that in the chat as well. But do bear in mind, guys, as you've seen, it's very easy to Google this stuff. So as long as you've captured the title of the thing you want, then you can probably just Google it and it will come up. I'll put the medical needs guidance in the chat too. There you go. And a question about linked obligations between local authorities and CCGs. Just to say about that, there is a principle that I'll explore more fully in the health social care talk, that there's a line for children across which local authorities can't go. They can't act as a substitute NHS for children. So where a child needs, for example, significant levels of nursing care, that will be an NHS responsibility. People know that the CCG is the local NHS. So we'll come back to that again in more detail at another time. But there is, although there are joint obligations, there are also points at which the system requires local authorities and the NHS to operate separately. Does section 9 apply to post-season provision? Yes, I think it does. It's a general principle. So it'd be up to anything that is a school. The Education Act doesn't apply to colleges, I think, although I'm just looking at that actually. Perhaps it does. Let's have a quick look. So people will now often forget about the Education Act because we're so focused on the Children and Families Act. Definition of further education. So there's a good chance that there's going to be something in here that's of relevance to colleges. Let's look at the wording of section 9. Right, so the duty in relation to section 9 is imposed on this formally on the Secretary of State and local authorities. So yes, in the context of discussion with local authorities, individual schools and colleges don't have the section 9 duty. But I still think it's worth highlighting what the fact that this wording general principle is used, I think is useful, because that means that Parliament has expressed that there is a general principle that pupils are to be educated in accordance with the wishes of their parents. Now, formally, it's then applied that as a duty, having regard to that to Secretary of State and local authorities. It doesn't mean you can't cite it when you're discussing issues with schools, colleges, or anyone else of any relevance. Okay, so what I'm going to do is stop there, everyone. Let everyone have a break, because I think an hour of me banging on about the law is more than enough for everybody. And we'll start again at 11:30 when I will be switching straight to the Equality Act, and hopefully then clearing some more of the questions in the Q&A, because lots of them have already anticipated Equality Act duties. So we'll take a 15-minute break just over, and I'll see everyone back at 11:30. Thanks very much. Okay, hi everyone. Hope you've managed to refresh yourself. Sorry we couldn't offer teas and coffees. This is the brave new world, isn't it? Remote learning. But I'm going to crack on straight away now with the introduction to the Equality Act, and then take a moment to look at any other comments or questions that I need to deal with that have come in during the break. So just one moment before I share my screen. There's a couple of things that I shouldn't be sharing. Let's go back to the legislation. And again, to prove how easy it is to find the law, is the Equality Act. So what the Equality Act did back in 2010 now, is it got rid of the old issue-specific pieces of discrimination legislation, in particular in our case, the Disability Discrimination Act, 1995, and created this single code, statutory code, for the promotion and protection of equality rights. And we see that the way that Act is structured, we forget about part one because that's not in force, is we have part two, which is key concepts in relation to equality. The first set of key concepts concerns the protected characteristics, which we're going to look at in a moment, in particular, the characteristic of disability. And then the Act goes on to define a series of forms of prohibited conduct, the different kinds of discrimination that people might face, which we'll look at as well. And what Parliament then did was apply these principles, these concepts to different areas of life. So first of all, in relation to services and public functions, then in relation to premises, work, which is a huge area, of course, lots of Equality Act claims will concern employment. Lots and lots on here. And then, for our purposes, part 6 concerns education. So we have chapter 1 that concerns schools, chapter 2, FE and HE, qualifications bodies, and then some miscellaneous provisions. And we also have a whole host of schedules, as we'll see, ones that concern us. So first of all, Schedule 1, which is about the definition of disability. We won't spend much time on that today, if any. But then we have Schedule 10, which is about accessibility for disabled pupils, the exceptions for schools in Schedule 11, further and higher education exceptions in Schedule 12, and reasonable adjustments duty is spelled out in Schedule 13. So Schedules 10 to 13 need a little bit of thought as well, because that's where the detail is. So that's the scheme, that's what we're going to be looking at before we get to those bits of detail. The protected characteristic of disability. So in order to claim that you've been discriminated against in relation to being a disabled person, you must have a disability as defined in Section 6. And we see that the definition is that the person has a physical or mental impairment. And so the starting point is you've got to have a physical or mental impairment. So there's a medical approach taken here. However, it doesn't have to be diagnosed. You don't have to have a label that's associated with it, but you must have a physical or mental impairment. And that must be accepted or found on the balance of probabilities. If you don't, then we don't get anywhere, and we can forget about bringing any kind of claim under the Equality Act in relation to that protected characteristic. And then the impairment has to have a substantial and long-term adverse effect on your ability to carry out normal day-to-day activity. So that's the test. Does your impairment have a substantial and long-term adverse effect on your day-to-day function? And again, those bars aren't too high. Substantial, more than minor or trivial. Long-term means more than 12 months. So very many children with special educational needs will also have a disability. Not all, but I would say the large majority, although that may not be understood and may not be agreed, because many of those children will have a mental impairment, for example, ADHD or anxiety or any other form of recognized mental impairment that has a substantial long-term adverse effect on them, and therefore they will be a disabled person. There's some quite useful guidance by the Equality and Human Rights Commission. Here it is. So I'll put this link into the chat as well. Guidance on matters to be taken into account in determining questions related to the definition of disability. So if you are in a situation where you're having an argument about whether you're a young person or you yourself are disabled, have a look at this guidance. But in the vast majority of cases, it isn't actually in dispute that the person is disabled. That is often, in my experience, agreed. The question then arises, which is have they been discriminated against? So let's see what that's likely to mean. So there are 4 key types of prohibited conduct that are likely to come up for disabled people generally and in a school's context in particular. Now, the first is just direct discrimination. Now, hopefully, this is pretty rare. as we see, for direct discrimination to happen, a person discriminates against another if, because of a protected characteristic, A treats B less favorably than A treats or would treat others. So it would be, you cannot come to my school because you are in a wheelchair or because you are autistic. Now, hopefully, those kinds of really blatant and overt forms of discrimination are primarily in the past. I'm not saying direct discrimination never comes up, but it's pretty unlikely, I would hope. So much more common will be indirect discrimination under Section 19. Now, indirect discrimination is much more complicated, I'm afraid, than direct discrimination, but it's extremely important. So I'm going to spend a little bit of time working our way through the statutory test for indirect discrimination. So we see that a person discriminates against another. So here it would be the school discriminating against the disabled child. If the school applies to the child a provision, criterion, or practice which is discriminatory in relation to a relevant protected characteristic. So here, in relation to the child's disability. So the very first thing we have to understand is what is a provision, criterion, or practice? And all the case law and the guidance tells us that those terms are to be interpreted broadly. So essentially, that means any rules the school has, any guidance, any policies, anything that it does that governs the way it behaves will be a PCP, as it's known. But it's fundamentally important, if you're trying to argue there's been indirect discrimination, that you identify the PCP. What is the measure? What is the thing that is causing the problem? And there may be more than one of them, but you have to be clear what the PCP is or what they are. And then we get a definition in 19.2 of what it means for a PCP to be discriminatory. So first of all, that it's generally applicable, or more specifically, that the school applies or would apply it to all the pupils or to a large subset of people, say the school, the sixth form. Now, let's take an example. A school that says that pupils can only go to the prom if they've achieved a 95% attendance in the year. So that's a PCP, without doubt, and it applies generally. So we get through the first gateway, we're through 2A. Then the next question is that the PCP puts or would put disabled pupils at a particular disadvantage when compared with non-disabled pupils. Now, I think it will be quite straightforward that my PCP in my example meets that test as well, because it will be much harder for disabled pupils as a class to achieve a 95% attendance because of health conditions or other reasons, which may mean that they can't be at school. Then, importantly, at 2C, it's got to put you, as in the particular child, at that disadvantage. So you would have to be a child, in my example, that was struggling to achieve the 95% attendance because of the need to attend a hospital appointment or any other reason. And so if you get through A, B, and C as the family in my example, that's essentially your job done. At that point, the burden shifts, and the school then has to show that the PCP is a proportionate means of achieving a legitimate aim, and that's called justification. So can the school justify having such a PCP? Two steps. First of all, they've got to identify a legitimate aim. Now, I presume in the example I've just given, they would say that the legitimate aim is incentivizing high levels of attendance, which I think on balance, a tribunal will be likely to accept. That's not even on balance, and they just would accept that is a legitimate aim. So the key question is, in my example, and will usually be, is it proportionate? Is the measure proportionate to that aim? And there's a lot of case law on proportionality, but at its essence, what proportionality gets at is the idea of striking a fair balance between the rights of the individuals who may be adversely affected here and any wider interest. And my strong view is that a hard-edged PCP like that doesn't admit of any exceptions is very unlikely to be proportionate. It will not strike a fair balance between the rights of disabled children and others and any wider interest. And so in a claim under the Equality Act, I would suggest it's very likely that a school would lose if it was challenged for having such a policy. So I hope that's a useful example of the kind of rule, the kind of PCP that can be indirectly discriminatory. There's also, of course, PCPs that are negative, because this is about denying a benefit. There's also very often behaviour policies or other rules that can be punitive and which can disproportionately impact on disabled pupils in a way that can't be justified. And those can also be indirectly discriminatory. Or indeed, there can be rules that breach other protected characteristics rights in terms of indirect discrimination. For example, policies in relation to the way that hair can be worn have been shown to be indirectly discriminatory on grounds of race or religion and belief. So it's not all about disability, of course, although this talk is all about disability, and we're focusing on what the implications of the Equality Act might be for disabled children and young people today. So that's indirect discrimination. Then the next form of prohibited conduct we need to look at is the one that's specific to disabled children and young people, which is section 15, discrimination arising from disability. So this is the old, this would have replaced the old prohibition on less favourable treatment under the Disability Discrimination Act, which was rendered pretty much useless by a House of Lords judgment in a case called Malcolm. And so instead, Parliament enacted section 15, which says that A discriminates against B. So again, the school discriminates against the child if A treats B unfavourably because of something arising in consequence of their disability. Now that's really important. We've seen already for direct discrimination, there has to be a causal link between the disability and the treatment. The kind of no Irish, no blacks, no dogs signs that we might have seen in the 1950s and 60s, and that hopefully we don't see anymore now. Section 15 is getting at something rather more subtle, which is where you're treated unfavourably because of something that's linked to, that arises in consequence of your disability. For example, the way you communicate or the way you behave. So to take another example, an autistic child is made to queue at school for lunch, and they can't handle the sensory experience and the stress of being made to queue, and they kick off and they push a teaching assistant, and they then get excluded for 2 days. So in that scenario, that child has clearly been treated unfavourably because a school exclusion is always unfavourable treatment. And the question would be, was that exclusion because of something arising in consequence of their disability? And it should be relatively straightforward to show that it was, because the behaviour, the pushing, arose in consequence of the child being autistic and not being able to handle the environmental stress. So then if you get that far, as often you will, again, the burden shifts, and this is now becoming familiar. The question is, can the school show that what it's done is a proportionate means of achieving a legitimate aim? So the school will say the legitimate aim is improving standards of behaviour. Fine, of course it is. Again, the question will be, is it proportionate to give a child 2 days fixed term exclusion when the cause of their behaviour, it might be said, is the school failing to make adjustments, as we'll see, to the environment and to its policies that would have reduced the stress and avoided that kind of outburst? And that will be a question for the panel or the tribunal if any claim is brought. And we'll see the only exception here is if the school didn't know and could not reasonably have been expected to know, but the child had a disability, which is why, generally speaking, I would say it's useful and helpful for people to be upfront about diagnoses and inform schools and other bodies that a child is disabled, because that gives them these protections under the Equality Act that might otherwise be denied. There was a problem with the use of section 15 until a few years ago, which was that under some regulations that were brought in under the Equality Act, children who had a tendency to physical abuse were excluded from the protection of the Equality Act. And that term was interpreted very loosely. So a tendency could be more than one, doing something more than once, and physical abuse, the bar was set very low. And so what it meant was that parents would say, well, that's discrimination arising from disability. And the school's response would be, well, no, your child's not disabled because they have a tendency to physical abuse. In a case I was instructed in called C&C, the upper tribunal rewrote the law there, essentially reinterpreted the law to say, no, if the child has a recognised impairment that can contribute to challenging behaviour, you can't just exclude them from the definition of being disabled using that regulation. It would be a breach of their human rights. So the good news is that this protection still applies to any child, no matter what they've done. And the question always will be, can the school justify it? Of course, the more serious and severe and the more culpable the child is for the behaviour, then the more likely it is the school will be able to justify it. So it's not a get out of jail free card for disabled pupils, but it does mean that schools have to justify excluding, for example, disabled children or subjecting them to any other kind of detriment because of something arising in consequence of their disability. So that's section 15, which is the first of the specific protections that the Act gives to disabled people. And then we finally get to the thing that everyone was asking about, which is the duty to make reasonable adjustments, which again is disability specific. And we see that actually there are 3 duties. So the duty comprises the following 3 requirements. The first is a requirement where a PCP of a school puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with non-disabled people. There is a duty to take such steps as is reasonable to have to take to avoid the disadvantage. So again, here we need to identify the PCP. So if we go back to my last example, the PCP there would be making kids queue for lunch. So that's a PCP, that's a provision, criterion, or practice. Does it put disabled people at a substantial disadvantage? Well, yes, if they're autistic, it certainly does. And then the duty is to take steps as it's reasonable to have to take to avoid the disadvantage. So could children who find it difficult to queue be excluded from queuing? Can they go to the front of the queue? Can another arrangement be made that is reasonable, that isn't unreasonable in terms of its implications for the school or for other people? So that's the PCP duty. Then there's the duty in relation to physical features, but this duty doesn't apply to schools because schools instead have their accessibility planning duty, which we saw brief mention of earlier. So we can skip over that. And then the third requirement, and this is important, is a requirement to provide auxiliary aids where a disabled child, in our case, will be put at a substantial disadvantage in relation to non-disabled children. The duty is to take such steps as reasonable to have to take to provide the aid. And importantly, an aid includes a service, includes a person, sorry. Here we are. So because of subsection 11, a reference to an auxiliary aid includes a reference to an auxiliary service, which can include people. So this is another way of getting, for example, a teaching assistant or a helper to go on a school trip. You don't have to have an EHC plan to specify that kind of provision. You can argue that there's an obligation on the school to make a reasonable adjustment to provide that person, because otherwise the child or young person wouldn't, for example, be able to access the after-school club or the trip. So really for schools, there are 2 duties. One is in relation to changing PCPs, where the PCP itself causes the disadvantage. And the other is to make adjustments through providing auxiliary aids and services. So I'll stop. Oh, hang on a second, just to show you the complete picture. Section 21 is the duty, is actually what makes this a duty. So a failure to do any of these things is a failure to comply with the duty to make reasonable adjustments. And A discriminates against the disabled person if they fail to do that. So if you were ever arguing a breach of the reasonable adjustments duty, you need to refer to both section 20 and section 21. So before I look at the questions, just to show you in outline terms, because clearly we're not going to have time to go through it all, the duties in relation to education. So we see, first of all, in part 6, section 84 applies the chapter to protected characteristics apart from age and marital civil partnership. So we know that it applies it to disability. Section 85 then says what schools are not allowed to do. And this is really important. So it's not a freestanding duty. Schools mustn't discriminate. They must not discriminate by doing any of these things. So the responsible body of a school must not discriminate against the person in the arrangements it makes for deciding who's admitted, terms for admission, or by not admitting them. So in relation to admissions. They mustn't discriminate in the way they provide education, the way they afford the people access to a benefit, facility, or service by not providing education, not affording access, by excluding, so the exclusions are specifically covered, or by subjecting the people to any other detriment. That's quite important. And they mustn't harass or victimize. We haven't looked at harassment or victimization. I will mention those in just a moment, just to complete the picture. So it's a very broad set of obligations, and importantly, the duty to make reasonable adjustments applies to schools as well. And we see which schools are covered, including independent educational institutions. So independent schools, private schools are covered by these duties. And we have a link somewhere, which was here, to the schedule as well. That's section 85. Section 86 can be quite important, not allowed to victimize or do anything otherwise bad to pupils for the conduct of their parents. It's something I have seen sadly happen. And then section 88 is going to be important because this is the accessibility provisions for disabled pupils, bringing into effect schedule 10, as we saw a moment ago. And then if we look, I'm not going to go into the further and higher education or the qualifications bodies provisions for now, just for reasons of time, but you've got here where you would be looking if you were interested in those areas. Reasonable adjustments, this is where Schedule 13 is brought into effect. So the Act itself has to bring in the schedules, which we're going to go and look at in a moment. In fact, we're going to go and look at them now. So schedule. We're not going to worry about the disability provisions for now. You know where that is if you need it. Start with Schedule 10, which is accessibility for disabled pupils. And we see the local authority in relation to schools, for which it's the responsible body. So maintain schools must prepare an accessibility strategy, showing how they're going to increase participation in the curriculum, improve the physical environment, and improve the delivery of information. Must be kept under review and revised, and so on. And then schools in England and Wales must prepare an accessibility plan. So every school has to have an accessibility plan that covers the same things: curriculum, physical environment, and information. And I would say it's the physical environment one that's particularly important here, given that we know the physical features duty doesn't apply under the reasonable adjustments duty. Secretary of State can make directions if people are failing to do this. So that's Schedule 10, isn't it? Yeah, accessibility. Then we get some exceptions in relation to, for example, single-sex schools. I don't think we're going to see any relevant exceptions here in relation to disability. Oh no, here we are. Yes, so permitted forms of selection. So you can have a permitted form of selection in relation to academic ability, essentially, or other forms of ability, if you're a certain type of school, for example, a private school. That's quite important. Otherwise, that would be blatantly indirectly discriminatory against disabled pupils. Schedule 12, we won't deal with because that's further and higher education. And then Schedule 13 is the reasonable adjustments duty for schools. So we see that the responsible bodies of schools under Section 85 must comply with the first and third requirements, not the second. The second is physical features. And then there are some other slightly technical points here. And we see that the relevant matters, importantly, are defined as being deciding who is offered admission as a pupil and the provision of education or the access to a benefit, facility, or service. What's not listed there is exclusions. So there's no reasonable adjustments duty in relation to the decision to exclude itself. But it is clear that whether or not reasonable adjustments have been made in relation to these things are highly relevant if, for example, you're going to argue that the exclusion was unlawful by reference to Section 15, which is the duty not to have discrimination arising from disability. So slightly complicated picture there. You can't say straightforwardly, you should have made a reasonable adjustment by not excluding. Lots of people do say that, but it's not actually strictly correct at law. What you mean is you shouldn't have excluded because there were things that you should have done in the run-up to the exclusion that would have made things better. And those would have been reasonable adjustments, and you therefore wouldn't have had to exclude the child. So just to complete the picture on the legislation, then I'll stop for questions and we'll look at a bit of guidance. There's always going to be some guidance. Just I've mentioned already harassment and victimization. So harassment, unwanted conduct related to a relevant protected characteristic with the purpose or effect of violating the person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Sadly, that is something, of course, that could be relevant in relation to disability, which we see as a listed protected characteristic here. And victimization is where you essentially suffer a detriment because you've tried to enforce your rights under the Act. So as we see, a person victimizes another if they subject them to detriment because they do a protected act, or they think that they're going to do a protected act. And a protected act includes bringing proceedings under this Act, being a witness, doing anything else in relation to this with this Act, or making an allegation there's been a breach of this Act. So if you were to say to a school, I think that you, in the way in which you made Johnny queue up for lunch, you failed to make reasonable adjustments, and the school then gave Johnny 3 detentions in a row without there being any obvious reason, you would be perfectly entitled to argue that your allegation of a breach, even though you didn't do anything more with it, was itself a protected act, and there's therefore been victimization. I think it will be clear. I think it will be sufficient that the child suffers a detriment because the parent has done a protected act on their behalf. I'm pretty confident that the core tribunal would agree that that's still victimization, although I haven't thankfully had to research that point for any particular case so far. So it's worth knowing what harassment and victimization are, but happily they are quite rare in my experience, and we're much more likely to be dealing with three types of prohibited conduct: indirect discrimination, discrimination arising from disability, and the failure to make reasonable adjustments. So that's section 19, section 15, and sections 20 to 21. And just another important point in terms of when you're making a comparison, when you need to make a comparison, as you've seen you often do. So under section 19 for indirect discrimination, there has to be no material difference between the circumstances relating to each case. So for example, if you had which example did I use? Oh, I used the school prom example. So you would say there's no material difference because all of these children are children at the school and they all want to go to the prom. So therefore they are a relevant comparator group. And if you're running direct discrimination under section 13, the circumstances related to a case include the person's ability if the protected characteristic is disability. But as I say, thankfully, we don't have very many direct discrimination cases. Anything else I need to flag up here? Irrelevance of the alleged discriminator's characteristics, that's quite fun. Doesn't matter whether the person who's done the discriminating is themselves disabled or has any other relevant characteristic. And so if someone describes disability discrimination, this is quite useful. We see that list that I've just gone through. Section 13, indirect discrimination, direct discrimination because of disability. Section 15, discrimination arising from disability. Section 19, indirect discrimination because of disability. Or section 21, the failure to make reasonable adjustments. Okay, that's probably quite enough from me for now. I'll jump into the questions and see if there's anything else I need to answer. So I'll go back up to the top and see if there are any reasonable adjustments questions from earlier that I can now answer. Okay. Those are all your CPO questions. Right, so the question was, how do I ask for reasonable adjustments to be made regarding school hours? The attendance policy doesn't cover disabilities at all. Attendance is slightly lower because of autism and sleep issues. So I'll use that as a case study. I'm not giving advice on a particular case, but I think we can now see that's a great example of a PCP adjustment, isn't it? So we're in the first category of adjustments that are needed. So you've got a rigid attendance policy. It's causing a detriment because presumably the child is not getting a benefit or is suffering some kind of punishment for not attending enough. And therefore the duty is to make such adjustments as are reasonable to make to that policy. Is consistency of one-to-one a reasonable adjustment rather than just who is free if consistency isn't specified in the HC plan? Yes, I think it is. So the piece, again, you've got to identify the PCP. The PCP then would be having a practice of allocating lots of different teaching assistants to a child because that's more convenient for the school rather than giving them a dedicated one-to-one. And if that practice is causing detriment to your child, I think it will be fair to say, therefore, that it will be causing detriment generally, and it will be putting them at a disadvantage compared to non-disabled children. So the duty again will be to make such adjustments as are reasonable. And the school might say, well, it's not reasonable because whatever reason, resources, whatever it might be. And that'll be a matter for them to justify. Blanket behaviour policies. Well, behaviour policies are the most likely thing, I would suggest, to give rise to disability discrimination, both in terms of indirect discrimination and a failure to make reasonable adjustments. I'm astonished there aren't more claims, frankly, in relation to behaviour policies. But we perhaps can look at why that is in a moment when we look at the tribunal. Adjustments questions. Could a child be allowed to take fewer GCSEs? Yes, again, that would be a perfectly good, reasonable adjustment, wouldn't it? So the PCP would be requiring children to take a certain minimum number of GCSEs, and the adjustment is not requiring that in a case where it would prejudice a disabled child. A great question, great legal question. What's the balance of probability I mentioned earlier? 51%, something that is more likely than not. So on balance, which is usually the test that is applied in civil law, did the thing happen, or is a particular test met? Would a reasonable adjustment apply to a child with sensory issues having to wear certain pieces of uniform? Yes, absolutely. One would very much see that an adjustment to the uniform policy could well be reasonable in that scenario if being required to wear that piece of uniform prejudices the child. And it could also very likely be indirectly discriminatory as well, because it's hard to see how a rigid policy that doesn't take account of sensory issues can be justified. An interesting question. Could the lack of a requirement for local authorities to provide school transport for children and young people to after-school activities amount to indirect discrimination? Yes, but there is a duty to provide such transport, interestingly. It's in the Chronically Sick and Disabled Persons Act. So anyone in that situation, I think, would probably be best off arguing that actually the local authority is just in breach of its CSDPA duty. And then secondarily, if you're wrong about that, they should make a reasonable adjustment to their general policy of not providing transport. And the adjustment is provide the transport to the disabled child, because otherwise they can't get to the activity. When a school offers rewards for attendance that put SEN children at a disadvantage, should they not have those rewards? My strong view is no, they shouldn't. It's completely wrong, in my view, not morally or ethically, but legally, which is the bit I'm interested in, to have attendance reward policies, because it inherently discriminates against disabled children, because as a class, disabled children are much less likely to be able to hit those targets. Now, I don't yet know there's any deciding cases on that. I'd be very keen to bring one and get a judgment that says so. But it's certainly something I think there should be pushback on, because it prioritizes and privileges the mainstream, the non-disabled mainstream, ahead of the minority. And yes, equally true of behaviour policies. So a behaviour policy that raises aggressive behaviour leading to exclusion, that makes no allowances for impulsive behaviour. Precisely the kind of thing that I would regularly be arguing is both indirectly discriminatory and demonstrates a failure to make reasonable adjustments. Because as long as you don't say it's the exclusion you're challenging, you can say the policy is itself a breach of the reasonable adjustments duty, and it's the PCP that ought to be adjusted. What's a schedule within an act compared to sections? Very good question. So the devil is in the detail, isn't it? And the schedules is where the detail is. So let me give you another quick example of that that's going to be relevant. I want to talk to you later. The Children Act 1989. Section 17 is the general duty for all children in need. So if you have any interest in social care for disabled children, you will need to be very familiar with section 17. And what it says in here in 17.2 is that for the purposes of facilitating the discharge of their general duty under this section, every local authority shall have the specific duties and powers set out in part 1 of schedule 2. So you go, okay, right, what does part 1 of schedule 2 say? We go back to the table of contents, we scroll down, I move my Q&A box so I can see what I'm doing. And we find the schedules, and here's schedule 2, and it's headed support for children and families. Sounds promising. And we look at the various paragraphs within the schedule, and we see, importantly, that at paragraph 6, there's some specific stuff about disabled children, which you wouldn't know if you just read section 17 on its own. And I'll go through what that says when we get to the social care talk. So the short answer is that the schedule provides the detail, then fleshes out the headline obligations in the main body of the Act itself. A question, does this Act apply to residential care? I'm going to assume for present purposes that this Act means the Equality Act. And the answer to that is yes. And the reason for that, and this is one that's worth keeping in mind as well, is that when you're not dealing with a school, you're probably dealing with a service provider. Service providers are covered by section 29. And we see that a person concerned with the provision of a service to the public or a section of the public, whether for payment or not, must not discriminate, etc. And then if it's any doubt that the thing is a service provider, you can then rely on 29(6), which refers to people providing who are exercising public functions. So the local authority, for example, may well not be providing the service itself, but in commissioning the service or deciding who gets it is exercising a public function. So section 29 is also worth bookmarking if you're concerned about discrimination by anyone other than schools. The question about GCSEs and alternative provision that I'm afraid is too general, too specific for me to answer here. Save that to say that, as I've already mentioned, I would suggest that a school that only provides GCSEs or A-levels and doesn't offer any other kind of qualification may well be indirectly discriminating against disabled pupils and/or failing to make a reasonable adjustment. Very often, you would argue both indirect discrimination and a failure to make a reasonable adjustment at the same time. So section 19 and section 20 and 21. And then the classic case study that I was expecting might come up. How about a child who's been told they can't go on a residential trip? Well, that's exactly the kind of scenario where the Equality Act is primed to assist, I would suggest, because whatever support might be required to enable the child to go on that trip will have to be provided if it's reasonable for the school to do so. And so the cost, the benefit to the child, the detriment to any other pupils all gets put in the mix, and we work out what's reasonable. Looking if there's anything else I need to deal with at the moment. So chat too. We've been posting the other talks that are coming, which is great. Yeah, so a comment, which I think I can share because it's from Sharon from the Trust. We hear from families a lot that schools will say, we don't think this school is for your child, very academic, or some other reason. Those are all red flags for potential disability discrimination, aren't they? And we've seen that duties apply in the context of admissions. And I mean, on one level, that's just direct discrimination, isn't it? Essentially saying, don't come here because you are a disabled child. You might say in the alternative, it's indirect discrimination, failure to make reasonable adjustments, throw the kitchen sink at it. But those kinds of comments are not acceptable, I would suggest. Yeah, and a comment that's really powerful about in the chat, told that one of the attendees' daughters would bring down the school's stats and don't apply or we'll fight you for it. I mean, how unwelcoming is that? And of course, it's all well and good me saying, well, that's obviously unlawful under the Equality Act, isn't it? But you don't get to go to school with a judge on your shoulder to tell people off if they get the law wrong. I do recognise that in the real world, the law can only go so far. And what we really need is attitude shifts, don't we? And I think strategic and targeted bits of challenge using the Equality Act can be really helpful in terms of changing attitudes and understanding that these kind of approaches are not acceptable. Okay, so thanks for all the comments and questions, everyone. If I haven't answered, it's probably because either the issue is for one of the future talks or because I can't work out how to make it general when it's too specific. So apologies about that. What I wanted to show you is what I think is a really useful piece of guidance from the Equality and Human Rights Commission. And it's called technical guidance, which is very off-putting, but it's actually not that technical. Schools in England. Now, this is yet another form of guidance. This is not a statutory code of practice. And it does tell us which section it's issued under and what its status is. I'm going to find that because it's a useful prompt for me to get the right bit. Here we go. Under section 13 of the Equality Act 2006, interestingly, it's not the 2010 Act, the act that set up the Equality and Human Rights Commission. And so it's not a statutory code, but it may be used as evidence in legal proceedings. I've always found that a bit strange. If education providers follow this guidance, it may help them to avoid the court making an adverse decision. So it's certainly highly persuasive in terms of what the law requires. And it goes through as everything we've just done in rather more detail. What I was going to look at in particular is some of the useful guidance about reasonable adjustments. So we've got here the overview of who has the legal obligations. All schools in England, irrespective of how they're funded or managed, have obligations under the Act. That's really useful. No one can try and say, oh, we'd have to follow the Equality Act. Of course you do. All schools. See here the links to the Children and Families Act, as you'd expect. Who's responsible, governing body, the proprietor, etc. Who's protected, we know about that. What's unlawful, we know about that. We know the different forms of unlawful discrimination. We know about harassment and victimization. So scrolling through it forward, excuse me, don't look at the screen for a moment or you're all going to get a headache. What's quite helpful about this guidance is it has lots of FAQs which give examples of the kind of scenarios that might come up and what might constitute discrimination in those scenarios. So we've got the chapter on admissions, which I'll scroll through. I think it's quite clear how that works. Again, look at that chapter if you are particularly concerned about not being admitted to a particular school. Chapter 3 is really important because actually I think where the Act has most teeth is in terms of challenging decision making in relation to children in a school, frankly. Whether you're going to want to sue your way into a school under the Equality Act, I would leave up to you. But certainly once you're in a school, if there's discriminatory conduct, you're going to want to challenge it. And we see again the summary of Section 85 that we looked at a moment ago in terms of what's covered and how broad it is. A school's obligation to pupils covers everything that a school provides for pupils. It goes beyond just the formal education it provides. All school activities, extracurricular and leisure activities, etc. Most discrimination in schools is unintentional. I would agree with that, in the sense that the conduct that is discriminatory is intended. It's just that no one realizes it's discriminatory. I think it's quite rare that schools deliberately set out to discriminate against disabled pupils, I'm pleased to say. But that doesn't matter, because if you've got a rigid policy or a practice that is discriminatory, it's unlawful whether you meant it to be or not. So we see the examples, the ones we've been talking about, timetabling, school uniform, etc. All teaching, as you'd expect. School trips, very importantly for us, people with a visual impairment is told who will not be able to attend a school camping trip. There you go, classic example of failure to make reasonable adjustments, and I would say indirect discrimination. Forward planning, really important point. So schools can't just hold up their hands and go, oh, we can't do that now. They need to think about ways in which they can make their offer more accessible for pupils with protected characteristics. Test assessment exams, pupils with Tourette's is excluded because of disturbing other pupils with their behaviour. That's discrimination arising from disability, as we saw under Section 15. And they're unlikely to be able to justify it because they failed to make reasonable adjustments for the link between the different forms of protected characteristics, prohibited conduct. So we just see how broad the definition, the coverage of the Equality Act is in terms of anything to do with a phrase that's often used, the life of the school is going to be covered. What's not covered, the content of the curriculum. So the content of the curriculum, as opposed to the delivery mechanisms. So a delivery mechanism is covered, but not what is actually taught, as you would expect. So for example, the Merchant of Venice can be taught even though it could be viewed as being hostile towards Jewish people. And some other exceptions that are not going to be relevant to us. Any other detriment interpreted very broadly, as we've seen. And some useful FAQs here as well. Exclusions. Unfortunately, that's going to be very important. And I'm going to show you briefly where the statutory guidance is on school exclusions as well. And so you have a choice if your child has been excluded from school, certainly permanently excluded. You can either go to the independent review panel, or you can bring a claim for discrimination against the school, or you can do both. You may well want to do both, but you'll need to get advice, of course, in that particular case. It's unlawful for a person to discriminate against a disabled pupil by excluding them from school, as you would expect. The question is it discriminatory? You can't do it, you can't exclude people because of a particular characteristic, of course, that's direct discrimination. Behaviour and exclusions policies that result in a higher proportion of pupils with a particular protected characteristic being excluded are likely to result in indirect discrimination unless their application can be justified. Keep that one in mind if you're concerned about school exclusions. So a rigid policy, 2 strikes and you're out, no adjustments, very, very likely to contravene this provision of paragraph 4.10 of the guidance. And then we've got some specific guidance on disabled pupils. If they're excluded for behaviour connected to his or her disability, this could be discrimination arising from disability, which is usually the form of discrimination that will be focused on. And here's an example that is absolutely classic. Pupil with autism is excluded for flapping his arms at a supply teacher, perceived to be threatening behaviour. This, ironically, I think the guidance gets wrong. We've just seen that there isn't a requirement to make reasonable adjustments in relation to the exclusion. Depends what you mean by the exclusion's process, perhaps the procedure, but I'm not sure that that's actually right. I might have to raise that with the Equality and Human Rights Commission. I'd like it to be correct, but I'm not sure that it is. So that's what we're talking about exclusions. Then we get the guidance in relation to some of the key concepts about what discrimination is. Direct discrimination we'll skip over because it's obvious and hopefully we don't see so much of it anyway. Skipping through. Based on associations, very important. Someone's treated less favourably because of their association with, for example, a disabled person. Advertising an intention to discriminate, not unheard of. The schools will do that. Harassment and victimisation we've heard about as well. Indirect discrimination. So this is core business for us now. We're in section 19. The school applies a provision criterion or practice in the same way for all pupils, but this has the effect of putting pupils sharing a protected characteristic at a particular disadvantage. It doesn't matter that it intends to disadvantage the pupils. What matters is whether it does or would disadvantage them. Disadvantage is not defined in the Act. This is quoted all the time. It could include denial of an opportunity or choice, deterrence, rejection, or exclusion. It doesn't have to be quantifiable, it doesn't have to be actual loss. It's enough that people can reasonably say that he or she would prefer to be treated differently. So it's a very low bar. Sometimes the link may be obvious, other times it's less obvious, but it still can be indirect discrimination. You may need statistics. You don't always have to have statistics. It all depends on the circumstances of the case. So, for example, a Muslim pupil who is made to make jelly with pork gelatin, pretty obviously indirect discriminatory. But you're often going to need more evidence than that. PCPs are also not defined, but interpreted widely, including arrangements, one-off decisions, importantly. So a one-off thing can be a PCP as well. May be written out formally or may simply have developed as the school worked out the best way of achieving its aims. So you can have a PCP even if it's not written down. And then we get the four-stage test in section 19.2 that we looked at before. Comparative approach. So once it's clear there's a PCP that puts pupils sharing the protected characteristics, so disabled pupils at a particular disadvantage, the next stage is to consider a comparison between disabled pupils and non-disabled pupils, where the circumstances are sufficiently similar for a comparison to be made, and we saw this before, no material differences in circumstances. And very, very importantly here, when you're looking at the group, you don't necessarily have to look at the whole group of disabled people. You can look at people with a particular disability. So you can say, for example, this PCP discriminates against autistic children. So that's very helpful. You don't have to show the class as a whole. And then you've got to compare the two pools, as it's often described. There can be a formal comparative exercise, asking all these questions, and look at whether there's a particular disadvantage, one compared to the other. But very often you don't need to go down quite such a formalistic route as this. It's obvious, often really quite obvious that something puts disabled pupils at a disadvantage compared to non-disabled pupils. All of the examples we've been discussing, I would think, fall into that obvious category. And then we get to justification. So if a school can show that the PCP is justifiable, then it won't amount to unlawful indirect discrimination. So the aim must be legal and non-discriminatory, must represent a real objective consideration. Here are some examples of legitimate aims. Most of the time there will be one. But even if the aim is legitimate, the means of achieving it must be proportionate. So that's when we focus on this idea of fair balance, appropriate and necessary. Financial cost can't be a justification on itself, but it can be part of the reason if there are other good reasons. That's quite important. And the more serious the disadvantage caused, the more convincing the justification must be. And then the link, if in the case of owing disability, the school's not complied with its duty to make reasonable adjustments, it'll be difficult for it to show that the treatment was proportionate. So that's really very important. Discrimination arising from disability, where a child is treated unfavorably because of something connected with their disability, that can't be justified. That is, I think, one of the more straightforward forms of disability discrimination that you will need to argue. So it's just those 3 steps that we need to go through that we looked at in the legislation itself here. The unfavourable treatment must be because of something that arises in consequence of the disability. There must be a connection between the unfavourable treatment and the disability. And again, the justification test is the same. We looked at knowledge and the need for knowledge and the relevance of reasonable adjustments. Again, skipping harassment and victimization. Just briefly want to look at what the guidance says about reasonable adjustments. I think if I remember right, there's a whole chapter on it. Maybe that there's not a whole chapter because there's actually a whole guidance document on it. Let's see. Ah, there we are, chapter 6. So as well as there being a whole specific bit of technical guidance on reasonable adjustments, we have this specific chapter within this guidance, which is very helpful. And so what it makes clear is that it was new to apply the auxiliary aids and services duty to schools. So it's not a new one applied in other contexts, but it was for the first time applied to schools through the Equality Act. So before it was just PCPs, now it's PCPs and auxiliary aids and services. And as we see, the duty is to take such steps as reasonable to have to take to avoid substantial disadvantage. Physical features doesn't apply to schools. We've seen that before. Many of the reasonable adjustments that schools are already making include auxiliary aids. So it's not all new. Don't panic, schools. And it requires schools to take positive steps. That's really important, I think. And the fact that it's anticipatory, to disabled people generally. We know what the definition of disability is. We know the link to SEN. We also know that substantial means more than minor or trivial. Obvious in many cases that there is a substantial disadvantage, as we saw before. In other cases, it will not be so obvious, but it will be no less a substantial disadvantage. For example, given this chronic fatigue syndrome. Those phrases aren't defined in the Act, so they take an ordinary meaning, PCP and auxiliary aids and services. Auxiliary aids and services means anything that constitutes additional support or assistance, including support from a member of staff, importantly. Reasonable steps. The Act doesn't say what's reasonable. And so the crux of the duty is not whether something is an auxiliary aid or an adjustment to a practice, but whether it's reasonable for the school to have to do it. Not possible to say what will or not be reasonable in advance, but there are some factors coming up that are going to be well worth looking at. These are the factors. So this list is well worth looking at. So the link to the Children and Families Act and any EHC plan, the resources of the school, obviously relevant, financial and other costs, how effective it's going to be to make the adjustment, practicability, effect of the disability on the individual, health and safety, and that's got to be real, not just made up, need to maintain standards, the interests of other pupils and prospective pupils. So those are just factors. They're not by any means a legal checklist, but they're things that it's worth looking at and thinking about in terms of potential matters that schools will take into account. But the way to deal with it, I would say, for families is this. If you think that there's been indirect discrimination, or you think there's been discrimination arising from disability, or you think there's been a failure to make reasonable adjustments, say it. Use the Act, talk about things in the language of the Act, keep talking about the Equality Act, and say that we believe X, and if you say we're wrong, tell us why. There's nothing wrong with raising the issue. I would avoid calling it an allegation for now. Raising the concern and letting the school explain itself. And it may be that that prompts the school to then take some advice for itself about what it should or should not do. So I hope that's been a useful whistle-stop tour of the Equality Act. Clearly, it merits a sort of full day's training in itself, but you at least now know, I think, first of all, disability is a relevant protected characteristic. There are some specific forms of prohibited conduct the ones that are most relevant for us are going to be indirect discrimination, discrimination arising from disability, and a failure to make reasonable adjustments. And you've got an idea as to what they are, and the technical guidance is generally, although caveat about the exclusions bit, very good as to how to then apply the law. So in the last couple of minutes, I'll just go back to see if there's any more questions that I need to deal with now. Yes, so I had flagged to my attention there's some unanswered questions, but that's because they're about EHC plans. So I'm going to come and cover those in the next section, okay? Next talk. I promise I won't let them go. Asked about whether there's any model letters. I believe that both SOS, SEN and IPSI have model letters that people can use. So that might be useful. A question about judicial review and the idea that it has these inbuilt stages to encourage resolution, but always being told the cost is prohibitive. Well, I think it is, unless you can get legal aid for most people. Because not to send a letter before action, but to actually issue the claim. As soon as you issue the claim, you're at the risk of having to pay the other side's costs, which can be thousands of pounds, even at that first stage. So I do accept that judicial review is a very difficult thing to contemplate unless you can get legal aid. Increasingly, people are crowdfunding using the Crowd Justice website. Good Law Project, of course, has had stunning success in terms of crowdfunding for litigation, but it's quite hard to raise the kinds of funds you need to litigate, unless you are the Good Law Project. So yes, no suggestion at all that it's a straightforward process, but it is worth exploring and certainly worth sending pre-action correspondence, perhaps, because there's no risk that you'll have to pay the other side's costs if you if the other side say no. At the pre-action stage, everyone bears their own costs. At least in all my experience of the last 13 years of practice, never say never, but never yet known anyone have to pay costs at the pre-action stage. Could a school say it won't carry out recommendations on a private assessment? It's not a statutory document. Well, yes, it can say it won't carry out the recommendation on a private assessment, but not because it's not a statutory document. A recommendation is a recommendation, and unless it's in an EHC plan, it's not binding on anyone in terms of the provision that has to be made. But a school would have to properly consider those recommendations. If it's not going to follow them, it may need to provide adequate reasons for not doing so. So yes, but I would say. Some more EHCP questions, which I'm looking forward to answering in the next session. Hope people can make that. To what extent is evidence required rather than perception? Yes, well, perception is, if you're in the context of the Equality Act, we talk about perception in terms of you're perceived to have a protected characteristic and then treated less favourably because of that. Of course, everything that's in dispute will always need to be evidenced, including the existence of a disability. And so the court or the tribunal would need to find, on balance of probabilities, that the person is disabled for things to go forward. And so I've mentioned a couple of times the tribunal. So the point is that in almost every other area, complaints go to court, to the county court. Employment goes to the employment tribunal, but these are bodies that can have significant implications in their judgments, including the award of damages. But the tribunal in relation to schools can't award damages if there's been a breach of the Equality Act. And I'm instructed on a judicial review claim challenging that. It's going to be heard later this year, but at present, you can't get damages if your school has discriminated against you as a disabled child, whereas you could if you sued the school in the county court for race discrimination, for example. So what's the point of an Equality Act claim? Well, it has to be about changing policies, achieving a finding, a vindication of your rights. So it has to be non-pecuniary, non-financial remedies in the school context. And then a last question that I'll answer now: could a reasonable adjustment be reduced to the length of an exclusion? Well, I think it depends whether you follow the EHRC technical guidance or not, because I think the technical guidance would suggest yes. But my understanding is no, because that would essentially be a adjustment to the exclusion itself. And I think that that's not within the scope of the reasonable adjustments duty. You might try and argue that having a policy of never reducing the length of exclusions is indirectly discriminatory against disabled children, but that might be rather difficult. But that's something that certainly you would need to get advice on. So I think I'll end with my usual plea But I really hope that everyone has found it useful today. And thank you very much for the kind comments on the chat. As it said, all the webinars have been recorded. The link will be on the Seashell YouTube channel in due course. And please do make sure that all of those of you who needed advice about your own individual case, please get it, and please do access those sources of advice. All of them are oversubscribed and massively in demand. But I think with persistence, or I'm confident with persistence, people will be able to get advice from one or more of those sources. So with that, I will hand back to Sharon to bring things to the end. Over to you, Sharon.